are trying a new setup tonight. I don't know. Do we like it? We don't know yet. We don't know if we like it. Trying to keep the light out of the way, but we'll see. Okay, let's turn off the sound. I'm way early so that I can just test out my equipment here. So everybody else is fine. It's me that's early. I'm not sure. I'm not sure about this, everyone. I'm not sure. Yeah, I don't know. I don't know. I've got a new light. Hello. I have a new light I'm attempting to use, everyone. I'm kind of changing my setting here a little bit. I'm not loving it. I'm not loving it yet. Did I fix the country? I'm still working on it. I needed more glue sticks. Oh my goodness. Oh my gosh. No, I'm early, everybody. I'm working on my setup here. I'm not sure. I'm not sure if I like it. I'm not sure. How's the light? Is the light enough? Do we not have enough light? Let's see. Nope, we certainly do not now. There we go. That's a bit better, but I'm not sure. Really, Hillary spoke out. Oh my gosh, good job. You know, we've been waiting, right? We've got Bernie. I have such a huge surprise coming for everybody about Bernie. It's not about politics. It's just my own personal surprise. Did you use eminent domain to take over the hubby's closet? Oh my gosh, he's offered it. He has offered the closet. He went in there even just today and was like, that's completely up to you if you want to use that. It's fine. I think it's okay if you want to do that. It's all right. So I thought that was really sweet of him. It's the least he can do. Oh my gosh. How are you doing? I'm doing okay. Yeah, I'm doing okay. I'm trying I've got a new setup here. I'm working on, everybody. That's why I'm here a bit early, is to try to see if I can. I don't like change. I don't care for the change here. So Obama gearing up, talking about Obamacare. Well, yeah. Oh my gosh, all I heard in my head was like, Obama, what you talking about? Oh my gosh, it looks good. Okay, all right. Well, I don't know, everybody. I'm not sure. I'm not sure. It looks great. Oh well, thanks. I'm not sure. So everybody, just keep this in mind. This is A, and then let me set up B here, and we'll see. I wanted to come on before my 7 o'clock deadline so that I could just try a couple of things out here and see what's gonna work. I think it's always good to try new things as long as they're legal things. So here we go. Now this is gonna be the moment where I have to make sure no other camera angle gets anything weird. You know what I'm saying? There we go. Yep, my tang was not in the shot. We love that. Oh my goodness gracious. Well, yeah, so this is the other one. So this is number 2 here. And let me turn this light off. I don't know. I don't know. Light sensitive. Yeah. Here we go. All right, so there's number 2. What do we think, everybody? Number 1 or number 2? A or B? 1 or 2? Oh my gosh. Okay, the first one, we got votes for that. I suppose we could put up a poll, but I'm lazy. Ooh, B, yes. Oh, yeah, an optometrist, number 1. Okay, this is the light I was using for the first one. I love it because it's pointed down. It's nice. Exactly. A or B? 3 or 4? Okay, I'm tracking now. I'm tracking the numbers here. All right, we've got B, A, and B. That's my favorite one when they say, or are they the same? And I'm like, yeah, they're the same. Thanks for having that option. We didn't always have that option. when you were a kid, for those of you that may remember. Like, I can't tell a difference. Like, well, you best tell a difference. Either one. Okay, B is all right. Number 2 is okay. They're both fine. All right. Better here or there? I tell you, my vision, I don't talk too much, like too much about it, but oh my gosh, it's atrocious. I had a doctor come in who was just, whatever. There's all kinds of doctors going on, and he was an optometrist, and he came in and was testing, and he's like, wait a minute, what? you can't you can't see this? And I said to him, I'm like, no, I can't. And he said, seriously, are you messing with me? And I'm like, I'm Gen X. I don't care to mess with you, sir. You're not that important to me. So no, I'm not messing with you. Can you get out now? Oh my gosh. For a minute, gonna jump off you go, Kaya. Yeah, off you go. We love it. Pick what's best for you. Right. So that's kind of what I'm trying to do. I need to change the lights up in my room. And it's a good change, everybody. For many of you who have been with me for a very, very long time. Hello, Kristen. Hi. You know that I had to go to Chicago back in October, and it was a very, very stressful time. I was starting a new regiment, and it's working, everybody. Keep your fingers crossed for me, okay? Keep your fingers crossed. And so because of that, I've had a lot of vision changes. So I'm so glad about that. I'm extremely glad about it. So now I need to kind of change a few things here and there with what's going on. So yes, it's a wonderful change. We're very pleased with it so far. I'm trying to kind of slow a process down that had kind of gotten out of control. So we were stressed too. Oh, Kristen, I know, I missed you all so much. I seriously did. I really, really did. I'll probably have to go back again in the fall, but I'm doing okay right now. So I'm very, very pleased about it. Very thankful, incredibly grateful. So that kind of this is how it goes. As a lot of people know who have, ongoing medical problems. It's kind of a heartbreaking situation when you can't quite get the answers you need. So. What's the difference between a dishwasher and a baby? The dishwasher doesn't cry when you fill it with... Oh my goodness, Justin. I gotta stop reading comments out loud before I... Oh my goodness gracious, everybody. That reminds me, one of my very first... It might have been my first live that I ever did on the TikTok. Oh my gosh, everyone. Oh, it was terrible. I was just reading through the comments, and someone was saying... that they were making pizza. And I said, oh, that's so interesting. You're making pizza. And what kind? And they said, well, the dough is a special kind of dough. And I was like, oh, what kind? And he's like, it's the kind with dill in it. And I was like, really? And then, of course, I said those two words together, and that was not appropriate at all. And at that point, it's like my first live, and it took me, I think, a couple months before I was ready to come back after that. I had to remind myself, like, don't just read the words. Look into it. Work through it in your head first before you just go after it and just read it all you want. Oh my goodness. Yeah, exactly. Read the teleprompter. I know, right? That's what happens. So you gotta be careful, everybody, reading the stuff. You gotta be careful. Oh my gosh. Oh, I know, Thomas. Oh, I know. I was saying at the top here, I came on a bit early to kind of reset everything here, because things are going well for me right now. So I had some vision changes which allowed me to change things up. Ooh, one more thing before we dive too far. So here's the background. All right. So this is one. I'm worried this feels like it's floating. So let me do the other one here. So this is the black, and then this is the blue here. So let's do the paperwork on the blue. See, I feel like the blue makes it so it doesn't seem like it's floating. What are we thinking? One or two? One or two? Was it black or blue? Black or blue? What are we thinking? He's that crazy report. Oh my gosh, I know. Blue all the way. Yeah, that's what I think too. I think too. Oh, I don't want to prejudice anybody here, but um, what do you think was a breakthrough? I'm on just a new medication regimen. Blue's better. Blue's better. Okay, blue for sure. For sure, blue's better. Yeah, I mean, I feel like again with the black, it's like we're floating in the abyss there. So yeah, I think the blue's better. I agree. I agree. So thank you everybody for your help trying. I'm going through this. I'm going through this new setup here, trying to get things sorted. Again, I wanted to remind everybody I am trying to move over here completely. I should be fully moved over, hopefully by the end of the week, actually. Well, we'll see. We'll see. Fingers crossed. We do that a lot. We do that a lot lately. A lot of fingers crossing. So happy to hear that. Yes, yes. I'm yeah, it's taken it's taken a lot. We'll see. Hopefully it will continue to trend in the right direction. So fingers crossed again. So everybody, seriously, I am really trying to move myself over here. Oh my gosh, I think I'm at 115,000 followers over on the TikTok, and I'm so incredibly thankful for that. There's just so many people over there that I can reach, which is great. But oh my gosh, the hoops that you gotta jump through, and the ability of not being able to say certain words, and man, I'm getting community guidelines warnings, so I'm getting a lot. It's just so much less stressful over here. We'll have to start crossing our toes. I know. Everything's getting crossed now, everyone. But I'm so much, oh my gosh, it's so much better over here. I really, really do enjoy it. So I think we've got the first week in April is when the extension is up for whatever that was that happened. Another extension could be put into place. We don't know. I mean, the world's gone crazy, so we don't really know, but I am really trying to make the move over here for sure. Love the nails. Oh, thank you so much. Yeah, thank you, thank you. So yeah, I'm trying to make the final jump here. I'm struggling right now because I have so many historical posts that I did. I've got, I don't know, maybe 800 posts that I made on cases, like cases and the different constitutional amendments and various things. So I'm trying to download all of that. And as I'm going through it, I'm posting, here and there some old ones. And I'm getting like uh, violations because they're saying it's like low quality. And I'm like, that hurts my feelings. I'm like, that's not low quality. That's like, that might be last year, but still, I gave it my best. It's like a personal insult to me that they were saying it was low quality. Ah, yes, yeah. So it's getting hinky. It's getting hinky over there. And also, I need to really start focusing on the Substack too. I find that the Substack is really, in my opinion, like the closest to the TikTok. So I got to keep working on it for sure. I've got to make my presence known there a bit better. Uh, Over there, and the trolls are out. Oh yeah, they are really out of control. It's like it's a lot. It's a lot. I'm glad. Yeah, I'm glad I left. Oh, I agree. I agree. I'm ready to. I'm ready to. Yeah, Substack. Yeah. Well, that's where it's at. I mean, that's some really cool stuff over there. I've got to just spend some time there, and figure out how all of that works. So, and I will. I will. I'll do my best. But you really like the Substack? Okay, good. Good. And that's what I'm hearing. I'm hearing a lot of people really like it over there. I know V has done some lives, I think, over there. Is that possible? Can you do lives on Substack? Am I getting that mixed up, or every post is high? Well, I mean, it was a post that's been on there forever. It's like, the original post didn't have anything negative. I was just like, TikTok, it hurt my feelings. So Substack's just another app, very similar to the TikTok. Okay, she did, or they did go live over there. Oh, I love it. I love it. Okay, and Aaron Parnas goes live over there. Okay, good. That's good to know. I really like. I love to hear that. I'm glad there are other places that you can do lives. Not just on the YouTube, not just one here. So the Blue Sky I've been on, but meh, I don't know. I do like the Blue Sky. It's just like I can't. I'm not consistent. My ADHD is just like blah all over the place. Oh, I think you're right. I would agree, Thomas. I think that's really the thing. I do have a Substack account. Hello, Chris. Welcome, welcome. I just haven't figured out how it works yet. Oh, I need to work on it. So, but I carved out. I got my name in there. I was like, here we go. Too much reading on the Blue Sky. It really reminds me of the Twitter. And I didn't really care for the Twitter. I wasn't a tweeter. I didn't twit tweet. I wasn't a tweeter Twitter. It just wasn't my style, but plenty of other people enjoyed. So I think that's great. Hear about the leaked audio tape of Vance talking about Elon? No, but I'm loving it. I'm loving that. Even if it's not true, I just love the idea of it. Oh, that's great. We love this because what happens when you try to start throwing your weight around like a big bully is that, you bully everybody, and then you start to figure out like, hey, wait a minute, everyone's, bullying me here. That's not cool. We don't like that. So, oh dear, everybody. Okay, here we go. All right. So, yeah, I totally got distracted here by my ring. I have a new ring. This is my new ring, and I just got distracted. I was making such an incredibly eloquent point, and then I saw my ring, and I was like, wow, that's amazing. I have to compliment myself on my own jewelry. Oh, my goodness. All right, all right. Midas and right. Interesting. Oh my gosh, right now, lately, Midas, like, go for it. The lawyer that was, yeah, I'm still waiting on more information. Oh, she was so young. I'm waiting on more info though before I go forward on that. Yeah, I'm loving it. I'm having fun with jewelry. Oh my gosh. I noticed I don't want to get, yeah, this one's the one that I try to wear when I'm pointing at my computer screen because it's a cocktail ring. It's a big ring. So, well, welcome in everybody. Welcome. I was on a bit early just to test out some lighting and various things. Thank you so much, everybody, for helping me out with that. I appreciate it. I am hoping we can go through the Talbott case tonight. This was one of our big cases on the closet docket, which, my goodness gracious, is growing. I think we're at 133 cases now as of today. So that's a lot. It's just a lot, everybody. This is one of the big ones. This is where we have our executive orders that don't necessarily set out specifically that transgender people cannot be in the military, but the wording makes it so that clearly transgender people cannot be in the military, which is just heartbreaking. So this judge wrote a 79-page opinion on it, and she did some really good work here. I thought she really made some excellent points. So I want to go through kind of like the first little part here of her decision and um, kind of talk about it, because one of the things that came out of it, and I posted this earlier on TikTok, one of the things that came out of her order here is that, oh, you're so welcome. I'm happy to help. Oh, absolutely. This is so important. This is one of our rock star cases. I mean, again, if you're trying to ban a group of people from serving in the military, from serving their own country, it's just, it's heartbreaking. So, 5-time draft. Oh, I know, Kaya. Oh, I know. I'm with you on that one. So we've got this request that was made of the defendants to file with the court where the different policy decisions are being done or being sent out to the different areas of the government. So what they did was they filed this, PD, what is it called? Sorry, everybody. It's the one Excel. Yeah, they put this little chart thing together, and then they've got these little memos that they sent out to like Secretary of Defense and various other places. So I thought that was really interesting. So we can go through that as well, so we can see what they're actually telling, what the discussion is on the inside of all of this stuff. But we've got to, of course, start with the most important piece, which was this decision. So 20 years. Very angry about what they're doing. Oh my gosh, there's just a lot. There's a lot. I mean, this is just one of many things. You know, we've had our veterans that have been fired. I mean, come on. And lots of reductions, reducing things and removing things like, heart. Oh my goodness. Yes. So it's a lot. It's a lot. Yeah. Right. Sorry, everyone. I'm just double checking here in the comments. All right. So, again, welcome in. Now, this past week, everyone, I spent a lot of time going through the JGG case, right? That's the El Salvador situation. And I will continue to do that. But I felt like I'd done so many posts on it that at this point it was okay to grab the next case that was, I thought really an important case to talk about. So as I roll my chair around here, everyone, let me get my sticky note ready. Dun, dun, dun. This decision just came out on the 18th, and the most recent filing was on the 21st, and we'll go through that filing. We'll just kind of go through the beginning of this case to give you some idea of what's going on here with her decision, and then we'll go through the evidence that's been submitted. Oh my gosh. All right, so we have Talbott here. By the way, we do have another case that was just filed, I think also on the 21st, with the same issue, and it's the plaintiff's name is Ireland. So I think that's interesting. We do have another one on file here to kind of keep our eye on. So this, we're talking about the executive orders and trans-military questions. Trans/military. There we go. There we go. So this is the executive order that's putting, I'm sorry, this is not the executive order. We'll make that into a box. We're going to check the box for an injunction. All right, check. We have an injunction in place. So injunction opinion here is what we'll be going through. Injunction opinion, and this was done on 3/18. There we go. All right, sticky note. As I sit here and talk to myself, like, sticky note. Okay. So just 1 second, everybody. I have forgotten something. I need to go grab it. So I'll be right back. BRB, just one moment. Okay, thank you for your patience. Sorry about that. Apologies. Hello, Snappy. How are you doing? Fanta 47. I know. Maybe. Perhaps. How to tag? Well, if you want to talk to anybody else, you just put the @ sign in front of it and then the name. Whatever their name is, and then it gives you like a list, and you can pick from the list of who it is you're trying to talk to. Does that make sense? So like you would go into the chat and you'd put at and then like JAM, and it'll give you a list of your choices. Hello, hello. It doesn't do that on your phone. Oh no, oh no. Oh, bummer. Hello, Tay. Hello. Only on your laptop. Okay, okay. All right, well, listen to me talking only about the laptops. Apologies, everybody. Right, unless you're on your phone. Right, right, right. All right, well, that's the extent of my knowledge, my vast knowledge on this. So, yes. Oh, okay, okay, that's good to know. All right. Is everybody on their iPhone right now? Seriously? Oh, my goodness. All right, I gotta be on my best behavior then. Oh my gosh. All right, all right, all right. So let me get started here. Again, we've got a judge who gave this decision down. So Judge Ray's, and it's again, it's very powerful. Okay, on your Android. What's an Android? Oh my, really, really. Oh my gosh, everybody. All right, all right. I didn't read the room properly. My bad. Good to know. Oh my gosh. All right. So let's get started again. We're talking about um, an executive order that came out that was followed up with multiple different things where um, they're trying to clearly remove certain people. What I thought she did that was amazing in this whole opinion is she just kept it very simple. She just said, you don't have any facts and evidence for what you're saying. You're saying this and you don't have any support for it. And it's just, as clear as day when she sets it out that way. So let's go ahead and get started. Memorandum opinion. In Executive Order 14.18.3, Trump focuses on prioritizing military excellence and readiness. So, again, that's the name of the executive order. The military's, quote, clear mission is to, quote, protect the American people and our homeland as the world's most lethal and effective fighting force. Like, I guess it's a beginning of some kind of a wrestling match or something. Service by transgender persons is inconsistent with this mission because they lack the requisite warrior ethos to achieve military excellence. I mean, that's like the first two sentences is she's pulling this out of that executive order, right? So that first footnote down here, she's saying the executive order does not employ the word transgender, but defendants concede the term it does use, those with gender identity that diverges from their biological sex, refers to transgender persons. So they say in the order that we're talking about this difference here, but we all know that it's transgender. All right, so back up here on February 26th of 2025, Secretary of Defense Peter Hegseth issued a policy to implement the executive order's directives, and they're calling it the Hegseth policy. It disqualifies transgender troops from service without an exemption. And we have footnote 2 here. The Hegseth policy also studiously does not employ the word transgender, but as issued, it bans transgender persons. Both the Department of Defense and Secretary Hegseth announced this inescapable fact via social media. So again, they're trying to use the language to get away with stuff, and the judge is like, no, we're not going to do that here. The president has the power, indeed the obligation, to ensure military readiness. At times, however, leaders have used concern for military readiness to deny marginalized persons the privilege of serving. Fill in the blank is not fully capable and will hinder combat effectiveness. Fill in the blank will disrupt unit cohesion and so diminish military effectiveness. Allowing fill in the blank to serve will undermine training, make it impossible to recruit successfully, and disrupt military order. And we have footnote 3 here, which is from Integrating the U.S. Military, where she has filed an amicus brief here. Oh, yeah, the discrimination is just off the charts, for sure, for sure. First minorities, then women in combat, then gays filled in the blank. Today, however, our military is stronger and our nation is safer for the millions of such blanks and other persons who serve. Then, footnote 4, she is citing another amicus brief here. This judge's words are just so powerful in this decision. Currently before the court is plaintiff's renewed application for preliminary injunction. So those who are serving have brought the lawsuit. Plaintiffs who are transgender claim the executive order and the Hegseth policy together the military ban and treats them as today's fill in the blank group. Seeking nothing more than to serve their country, they ask the court to enjoin the military ban. They claim that the Hegseth policy was rushed and reached a preordained result, contains no analysis, and has an exemption in name only. The ban at bottom invokes derogatory language to target a vulnerable group in violation of the Fifth Amendment. And she's citing the Constitution here. Not at all, say defendants. They assert that the military ban is necessary because transgender persons undermine military readiness and disrupt unit cohesion, good order, and discipline. Being transgender is inconsistent with high standards for service members' readiness, lethality, cohesion, honesty, humility, uniformity, and integrity. And she's citing that policy language. Gender ideology activists are unconcerned with the requirements of military service, like physical and mental health, selflessness, and unit cohesion. Transgender persons cannot maintain an honorable, truthful, and disciplined lifestyle. Their expression of sexual identity is not consistent with humility and selflessness. They also cost too much. This is the opposition's brief here. These are all direct quotes from the policies here. Plaintiffs beg to differ, and differ they can. Together, they have provided over 130 years of military service. They have served in roles ranging from senior military science instructor to artillery platoon commander to intelligence analyst to satellite operator to operations research analyst to naval flight officer to weapons officer. They have deployed around the globe from Afghanistan to Poland to Korea to Iraq to Kuwait to the USS Ronald Reagan and the USS George W. Bush. One is presently deployed in an active combat zone. They have earned more than 80 commendations, including a Bronze Star, 2 Global War on Terrorism Service medals, 2 Global War on Terrorism Expeditionary medals, numerous meritorious service medals, numerous commendation medals, Air and Space Outstanding Unit Awards, and the Military Outstanding Volunteer Service medals, among many others. Defendants rejoined that these service records are inapposite. The court must ignore them and instead defer to the military's judgment. Yes, the court must defer, but not blindly. The president issued Executive Order 1418-3 within 7 days of taking office. And Secretary Hegseth issued a policy 30 days later. There is no evidence that they consulted with uniformed military leaders before doing so. That's kind of a big deal here. Oh my goodness. Kaya, yes, happy birthday. Yay. Neither document contains any analysis nor cites any data. They pronounce that transgender persons are not honorable, truthful, or disciplined. But defense counsel concedes that these assertions are pure conjecture. So she's citing here back and forth with counsel. The court says, is saying that transgender people are people with gender dysphoria, that their inherent identity is inconsistent with the commitment to an honorable, truthful, and disciplined lifestyle. Is that demeaning to them? Defense counsel, I don't have a characterization for that, Your Honor. Wow. Yikes. The court. Okay, and if I asked you about all of the other words in the military ban with respect to the characterization of the transgender people or people with gender dysphoria, you would have the same answer? Yes, Your Honor. There's nothing supporting these assertions in the studies, right? That says those same things. No, Your Honor, not that I know of. No study says anything close to those things, correct? Not that I know of, Your Honor. Oh my goodness gracious. An action memo claims the policy was informed through consideration of 3 studies and cost data. Who considered the information, however, is anyone's guess. Defendants do not know. Maybe no one, because one study's 8 years old and the other 2 support plaintiff's position. Transgender persons have served openly since 2021, but defendants have not analyzed their service. That is unfortunate. Plaintiff service records alone are Exhibit A for the proposition that transgender persons can have the warrior ethos, physical and mental health, selflessness, honor, integrity, and discipline to ensure military excellence. Defendants agree. They agree that plaintiffs are mentally and physically fit to serve, have served honorably, and have satisfied the rigorous standards demanded of them. And she's citing to the transcript where the defendant uh, is agreeing. Plaintiffs, they acknowledge, have made America safer. So why discharge them and other decorated soldiers? Crickets from defendants on this key question. Oh my goodness. Our judges are getting pretty sassy, everybody. Plaintiffs have also introduced declarations from the military leaders responsible for integrating transgender persons into open military service. Each declarant attests that our military has not fallen into an existential crisis since transgender persons began serving openly in 2021, nor have our lethal and effective soldiers come unglued when asked to use preferred pronouns, which the HAGSEF policy also bans. To the contrary, they each testify that recruiting, unit cohesion, and military readiness have improved since 2021. To obtain an injunction, plaintiffs must establish a likelihood of success on the merits. They have done so. The court's factual findings, the vast majority conceded by defendants and all supported by the record, make it highly unlikely that the military ban will survive judicial review, whether it be rational basis or intermediate scrutiny. So, I will pause here for a moment to remind everybody that we have different scrutiny levels when we're considering the constitutionality of something. So let me just remind you, a rational basis is the lowest level where the government will always win. So we have the rational basis test, we have intermediate scrutiny, intermediate, and then we have strict. All right, this basically sets out how they're viewing the law that's been created. So, does the government have a rational basis connected to a goal? And so, usually they're going to win this one. So, this is the government winning. Intermediate, it could go either way. It could be the plaintiff, could be the government. Strict scrutiny, almost always, except for the Korematsu case, the Japanese American internment camps. Matsu. I'm sorry. Is it ZU? I apologize. I can't remember. Korematsu. This is where our race discrimination laws come under, and almost always the wronged party will win. The government will lose. All right. So there you go. Those are our 3 levels of scrutiny. So don't get too tangled up if that language doesn't sound familiar to you. Just know rational basis is the lowest level and the government's going to win typically. And then intermediate is that middle zone. So another way to take a look at these would be race is covered by strict scrutiny, sex is covered by intermediate, and then uh, like age or disability is under rational basis scrutiny. All right, so there you go. There's your 25-cent review there on constitutional levels of scrutiny. Plaintiffs must also show irreparable harm and that the balance of the equities and the public interest favor an injunction. Again, those are the 4 pieces of the test all of our judges have been using for these restraining order cases. On the former, plaintiffs face a violation of their constitutional rights, which constitutes irreparable harm. Thank you. No Z. Got it. Thank you. Appreciate it. I'm getting everywhere I look, I'm just seeing Mandarin. So I'm just seeing like Q's and Z's and X's just everywhere. Like they're not even there. I'm just seeing them there. That's what's happening. Indeed, the cruel irony is that thousands of transgender service members have sacrificed, some risking their lives to ensure for others, the very equal protection rights the military band seeks to deny them. On the latter, defendants have not shown that they will be burdened by continuing the status quo. Pending this litigation and avoiding constitutional violations is always in the public interest. So again, this whole paragraph are those 4 pieces required for an injunction. The court therefore grants plaintiffs renewed application for preliminary injunction. The court details the scope of the injunction in the order that accompanies this opinion. The court on its own motion, so we would call that sua sponte. Oh no. I just had it here. I'm going to put like Z's in it. Sua sponte. There we go. The court on its own motion stays its order, meaning it's halting its own order until March 21st at 10 a.m. Eastern to provide defendants time to consider filing an emergency stay with the DC Circuit. So she's saying, if you guys want to get your appeal going and the DC Circuit wants to go ahead and stay the case, I'll give you a little bit of time here before this goes into effect, that's really nice of her to do that. And the court does not issue this preliminary injunction lightly. Judicial overreach is no less pernicious than executive overreach. So true. But the coordinate branches must, by their mutual relations, be the means of keeping each other in their proper places. Ooh, we love that for us. We love that. The Federalist number 51, James Madison here. So hold on, everybody. I need to grab my cord. I'm sorry. I'm a little unprepared tonight. Just 1 second. My phone cord. All right, here we go. I apologize. Oh, my goodness gracious. I've been working too much on the closet docket, everybody. Too much on the docket. I gotta get my stuff sorted out. All right, okay, good. We're up and running again. I apologize. Yes. I was running for my cord. Sorry about that. Hey, Desert Skies, good to see you. Oh my goodness. All right, where were we? Right, Federalist paper. So, Federalist number 51. The president and defendants could have crafted a policy that balances the nation's need for a prepared military and Americans' right to equal protection. And they still can. The military ban, however, is not that policy. The court, therefore, must act to uphold the equal protection rights that the military defends every day. The court's opinion is long, but its premise is simple. In the self evident truth that all people are created equal, all means all, nothing more, and certainly nothing less. And we have footnote 5 here. Women were included in the sequel when passage of the 19th Amendment granted them the right to vote in 1920. And see, what did she cite? She's citing Hamilton. See, Lin-Manuel Miranda, Hamilton, an American musical. What? Oh my gosh. Oh, we love that. We love that. And compared to the U.S. Declaration of Independence with the U.S. Constitutional Amendment, this is the 19th Amendment, that right is one of many that thousands of transgender persons serve to protect. My goodness, we're all right. We're citing Hamilton. Let's do that then. I love it. Oh my goodness. All right, so here's our background. We'll go into the background just a little bit here. And I have something that I just got recently from Hamilton. Actually, let me just get it out since we're all friends here. We'll do a quick unboxing as we go through this. Here we go. What? What is this? Look at this, everybody. This is James Madison. What? The father of the Constitution. Da, 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 da. Oh my gosh, I was so excited when I came across the Hamilton cast in Funko Pop form. Like, are you kidding me? Yes. Yes, all of those yeses. I will take that. Oh my gosh. Yeah, I know, right? Right? I love it. I know, I love it. Look at this. He's got his little, and here's the other thing back here. He's got his little handkerchief because he always had the sniffles. Oh, I love it. All right. We're going to put Madison away. Back. Let's get back to it. Yeah, Funko Pop, man. That was a Funko Pop situation. I can't show you the front here, but here's the back. Yeah, we've got Hamilton, Madison, King George, and Jefferson. I'm looking for Jefferson still, but yeah. I know, right? Right? Okay. Here we go. Easily distracted tonight, everybody. Easily distracted. Here we go. So let's kind of look here. And I like how she put this background together because it kind of shows us like how all of this has developed, because we haven't always had the transgender people in the military situation. So we'll start with Obama. Transgender persons can serve. So footnote number 6. For an in-depth history, you can see Doe 1 v. Trump here, and this is 2017. So that was another lawsuit that had been filed. Before 2014, the United States precluded transgender persons from military service. This changed during President Barack Obama's second term. In 2014, the Department of Defense, or DoD, eliminated its categorical ban on service by transgender persons and instructed each branch of the armed forces to reassess the ban's rationales. In 2015, then Secretary of Defense Ashton Carter established a working group to identify issues related to open military service by transgender persons. To aid its work, the group commissioned the RAND Corporation's National Defense Research Institute to study the issue. And then we have footnote 7. The National Defense Research Institute is not a fly-by-night operation. It is a federally funded research and development center sponsored by the Office of the Secretary of Defense, the Joint Staff, and the Unified Combatant Commands, the Navy, the Marine Corps, the defense agencies, and defense intelligence community. After a year of research, Rand concluded that allowing transgender persons to serve openly would have a minimal impact on unit cohesion, and estimated the impact of transgender persons serving openly on readiness to be negligible. It further found that extending healthcare coverage for gender transition related treatments represented an exceedingly small proportion of healthcare expenditures, between 2.4 million and 8.4 million out of 49.3 billion dollars, or 0.017% at most of the Unified Medical Program budget. Relying in part on that report, the working group unanimously concluded that transgender people should be allowed to serve openly in the military. It found that prohibiting transgender people from serving undermines military effectiveness and readiness. Such a policy excludes qualified individuals on a basis that has no relevance to one's fitness to serve, and creates unexpected vacancies requiring expensive and time consuming recruitment and training replacements. To implement the working group's recommendations, in 2016, Secretary Carter issued Directive Type Memorandum 16-005 titled Military Service of Transgender Service Members. The Carter policy stated that open service by transgender service members, while being subject to the same standards and procedures as other members with regard to their medical fitness for duty, physical fitness, uniform and grooming, deployability, and retention, is consistent with military readiness and with strength through diversity. Military spends $84 million. Yeah, oh my gosh. Seriously? Come on. Oh my goodness. All right. I'm going to have to put that in a box and put that on the shelf. Both the Army and Air Force issued guidance allowing transgender individuals to serve openly starting in July and October of 2016. The Carter policy for acceding transgender persons to the military was set to take effect on June 30th of 2017. However, President Trump took office in January of 2017, and on June 30th, the date sessions were to start, then Secretary of Defense James Mattis deferred acceding transgender individuals into the military until January 1st of 2018. Next, Trump won. So she's going through Trump's first administration and setting out, again, a memo stating that transgender people cannot serve. So let me kind of fast forward here through this, because I do want to get into what the plaintiffs or what the defendants have actually filed. So we have President Trump orders a ban on transgender service. Again, this is in his first term. Courts enjoin the 2017 memo. DOD recommends revisions to the 2017 memo. The Mattis policy takes effect. And then Biden, back to transgender persons can serve again. So we had this 4 years of a mess, and then we had another executive order enabling all qualified Americans to serve their country in uniform. And then fast forward to Trump 2, so his current administration, and then we're back to transgender persons cannot serve. Trump again orders a ban on transgender service. So we go through all of this, but I think she's really, highlighting that we're going back and forth. We need an answer on this. We need a definitive answer. Litigation ensues then, and now we've got this lawsuit as one of multiples against the administration here. So we've got the Hegseth policy issues. So she sets all of those out. She's got findings of fact in here as well. Again, I'm fast forwarding because I would like to spend some time on the defendants' exhibits that they have filed. So the Hegseth policy bans all transgendered troops. This is the February 26th. It's very specific. Transgender troops are disqualified from service without an exemption. Just very simple. Defense counsel contends that the court must ignore Hegseth's public description of the policy that he wrote and that he's responsible for implementing. They tried to walk it back. And she's like, well, that's what he said. Number two, the military ban is based on conjecture. The administration rushed the Hegseth policy. So that's another thing too that we need to remember. And I know a lot of people are, kind of reporting. I use reporting in the sense of not necessarily mainstream media, but what we're hearing from people that talk about stuff is they're saying, well, right, you got to flood the zone. So that's the whole plan here. The administration's trying to flood the zone, overwhelm the courts. And one of the things to remember is when they're rushing around to flood the zone, they're rushing to file all of this stuff. And so even if they had taken their time and done it right, they could have gotten the results they wanted. But instead, they're rushing to get everything done all at once and they're screwing up. So that's why there are all of these lawsuits. I mean, one of many reasons why. But this particular policy that was put into place was just run through way too quick in order to, flood the zone. Defendant's evidence supports plaintiff's application. That's one of my favorite things. When Mr. Trump's team supports the opposing counsel, that's one of my favorite things. The Mattis policy, the 2021 Psychological Health Center review, which I think is great to put that in there. Tea break. Thank you, Desert Skies. And this is a 79-page decision, so at least she acknowledges that it's like really big. 2025 medical literature review. Military costs are set out. Again, I'm just going through this. We're missing evidence, by the way. If the military ban goes into effect, it will upend lives, ruin the career of thousands of persons, giving this potential impact. The evidence is not in the record, so they don't have enough information. Defendant's failure to consider the military's experience with transgender persons serving openly undercuts the military ban. Plaintiff's declarants. And challenge to one declarant's testimony. A standard of review is set out here. Preliminary injunction analysis. We've talked about this many times over the last few weeks. Plaintiff's complaint is ripe. Several times I've seen the injunctions pulled because issues become moot, but here we're good to go. Plaintiffs are likely to succeed on the merits. So this is another, like a sneak peek into this case continuing forward. I have no doubt, I mean, honestly, that this could go to SCOTUS because Trump's people are appealing everything, like all the way. There's no, all right, we're done, because he has unlimited attorney power out of the Department of Justice. So they can keep appealing and appealing. The one thing that is not on their side is time. So they're going to run out of time before these cases make it all the way up, right? Because if we are appealing it and then Mr. Trump's team is no longer in the administration, then that Department of Justice can just pull all these cases as long as, the judges agree. Deference to the military. Defendants seek too broad an application for deference, which is a really good analysis. She's saying you're going too far. And I think the best way to illustrate what she's talking about is to actually go through these little bits of the transcript. So these are from March 12th. So we had a hearing here. He hasn't won an appeal in forever. Well, he's not strong on appeals. I would say one of Mr. Trump's strength is like flooding everything with crap. He can just, doesn't sound right. Like, what am I trying to say? He can flood stuff. But when you actually go and wade through it, he's not very successful on that. Oh my goodness. Yes, right. All right, here we go. I'm sorry, I'm laughing at my own jokes here. The court. For every 1,000 people, we can expect less than 2 will require care for gender dysphoria. Can you explain to me, please, how 2 out of every 1,000 people negatively impact unit cohesion? Defense counsel, I don't have an answer for that beyond what's in the record. The court, well, there's no answer in the record. If there's an answer in the record, tell me what the answer in the record is. If there is no answer and you can't answer, that's fine. Defense counsel, these are judgments the military has made. I feel like his heart might, I don't know who defense counsel was, but I feel like their heart might not have been in it. Who knows? Who knows? The court, can you point to me any case in American history that says to a court you should defer on a military policy that replaces another military policy that was put into place after review by the President of the United States and careful review by the military leaders? You should ignore the latter and defer instead to a policy put into place by an individual who has been the Secretary of Defense for about 30 days and who cited in his reasoning two studies that undercut what he's doing. Ouch, that's a harsh burn. Defense counsel, I don't have a case that has every specific fact that's at issue here. The court, anything remotely close to this? Defense counsel. I think every single of the Supreme Court's and Court of Appeals military deference doctrines are deference to the current military. I think by definition, these are courts that are deferring to the current military judgments about an issue. Oh my gosh. The court. How can someone decide that a group of people are hurting unit cohesion and discipline if we have no records of them doing so and we don't even know who they are? Oh my goodness. Defense counsel. The person and the people who are entrusted to decide that question are the military and the president. And if there's not actual data to back something up, the question is a professional military judgment. Again, as I said, a prediction. Oh my gosh. Let's see how impressed the judge was with this. Courts do not owe the military blind deference. She was not impressed. Not impressed here. So we'll fast forward here a little bit further. Trump versus Hawaii. Oh, this is a big case, everybody. Heads up on this case. Trump v. Hawaii. This case was decided regarding the actual travel ban, not the band, the ban, B-A-N. And it was decided at a time, though, where the executive order was no longer ripe. So it became a moot issue. This is also the case where Chief Justice John Roberts said the Korematsu case was a horrible decision. So there's a lot going on in Trump v. Hawaii. It's a very interesting because, there was a ruling made on this case, but it didn't matter because Trump wasn't president anymore. So now it's like they're bringing it back to life again. So Trump v. Hawaii confirms that the military is not owed blind deference. That's true. That's very true. So going on. So she's got, and we've got another chart here, which I think is always helpful. So we've got Trump v. Hawaii. It has to be facially neutral. The ban is not. Months of numerous working groups removed from Muslim ban tweets. Transgender ban tweet posted the day after Hegseth policies issued. Multiple iterations of the ban. One iteration of the ban. No derogatory characterizations in the military ban. Alleged animus statements were outside the proclamation's text. Animus is in the ban's text. Like, they're not even trying. Legitimate waiver program. So there wasn't out here. There are waivers in names only for the military ban. Worldwide review process. No review process. So it's pretty huge. That's a huge difference between these two types of proclamations. So she's pulling out intermediate scrutiny. Again, our scrutiny sticky note here. We have 3 levels of scrutiny when it comes to constitutional questions. So she's talking about intermediate and goes through that analysis here. Again, we're going to fast forward. Military ban classifies on the basis of SEX. And again, intermediate is the SEX situation. Again, sex being assigned at birth. That's a science term, right? For clarification. The logic of Bostock applies to the equal protection analysis. Oh my gosh, Bostock, get out of here. I don't even want to talk to you. We're going to move past that because I don't want to deal with it. I want to deal with that case. Application of the military ban to both males and females does not negate plaintiff's individual rights to equal protection. Here, and then transgender persons are a quasi-suspect group. Well, that's interesting. I think that's a great way of putting that, actually, because our suspect group, right, that is on the basis of sex here for intermediate, transgender's not, that technically is not a full sex situation, everyone. Again, I'm not a doctor. I'm not using the science words right. But when they're saying here it's a quasi-suspect group, is because it's kind of like a offshoot of that ramp. So she's putting that in as well. All right, and then transgender persons face discrimination. They certainly do. Transgender persons contribute to society. They certainly do. I think I was watching, gosh, what was I watching? Something on YouTube, a clip from somebody who was saying that it was, oh my gosh, I just lost it and it was so good. It was so good. It was, cultural, not Holocaust. He didn't use the word Holocaust, but cultural, what's the word I'm looking for? Cultural, what's the word? Oh dear. Culture, oh my gosh. This is going to drive me crazy, everybody, until I can figure out the word. What's another word for, all right, hold on here. What was the word? Anyway, I thought it was brilliant, all right? And I thought, wow, that's an incredible way of cultural Armageddon. Yes. That's not the word. Genocide. Oh my gosh. There it is. Cultural genocide. Are you kidding me? That's freaking amazing. When I heard that, I thought, wow, that's just, you can't just toss a word like the gen of the side around. You can't just toss it around, in my opinion, because you have to be respectful for the impact that that's had on different people in the world. So I don't think you can just toss it around just for funsies. But what the administration is doing, I think, towards the LGBTQ population, but specifically towards the transgender element, I think that honestly, yeah, I think it's pretty accurate, in my opinion. Just my opinion, to put it that way. They are truly trying to get rid, right, to remove, and that it's heartbreaking. Anyway, all right, enough of that. All right, so the contributions to society, obviously, here, transgender persons have immutable characteristics. True. Here, so she goes into that a little bit further. Transgender persons constitute a minority lacking political power. Oh my gosh, so true. I know, right? Right, VC? I tell you, Bergerfell, yeah, and I think V put up a good post about that. Actually, they put up a post on YouTube about that too. But it's just like, no, I thought that was a really great choice of words. And again, I don't use that word lightly. All right, 3, application of intermediate scrutiny. So she's using that middle level scrutiny when it comes to this constitutional question, military readiness. Again, I'm just fast forwarding here, and we'll jump into the memo here in just a second. Unit cohesion, good order and discipline. She's going into that. That kind of an overbroad generalization is not appropriate here. It's just not appropriate. Disproportionate costs as well. The Hague South policies exemption provision, the animus involved. This is another key piece. Like they're not even hiding it. They're not even hiding the animus. Military bans fueled by the animus, which clearly is set out in the words of the proclamation. And the government's targeted transgender persons. Uh, Again, if you're just, that's not allowable. Not just oh, I know. Oh, I know, right? Oh my gosh, I know. It's heartbreaking, heartbreaking. Plaintiffs will suffer irreparable harm absent an injunction, which is that final piece that we're looking at, and then the public interest factor as well. So this again, everyone, I know I'm flipping through this here because I've got more to show you, but she did then grant the injunction, and she's got this 80-page opinion where she walks through that this is about discriminating a suspect group, and suspect being the legal term, when we've got different levels of scrutiny that need to be applied for constitutional rights. So these are equal protection constitutional questions here. So I thought it was a really good decision. Again, I can't read through all 80 pages because, that's, we got to keep moving on. We just don't have time. We have so much stuff going on right now. We don't even have time. But the decision is really good. If you want a full, and I think probably one of the most powerful court rulings I've seen on transgender people being discriminated against, just so clear. It's just so clear, and it's she's not trying to get everybody all riled up. She's just like, it's just very simple. Obviously they're incredibly discriminated against, and especially under this administration. So she does great work, highly recommend. But I want to dive into how the government is trying to justify what they're doing. All right, so let's take a peek at that. You gotta look at both sides, right? We have here, again, this was the filing done on the 21st. So just 2 days ago, they had filed to try to explain how the government's been giving guidance to different departments, right, on this executive order situation. And so the judge was like, tell me what's been shown to everybody, what the government's trying to do. So they put together this list of who got it and what it was. So we've got Department of the Navy, Navy Recruiting Command, and what they were given was a decision guidance memorandum, processing of applicants identifying as transgender. So we have these too. I mean, we've got these different pieces. Next, Secretary of Defense, defending women from gender ideology extremism. That's the executive order. Department of the Air Force, Office of the Assistant Secretary, implementation of the Executive Order 14168. And then, again, the same executive order. So Department of the Army, Office of the Assistant Secretary for Manpower and Reserve Affairs. Again, same thing. Secretary of Defense, prioritizing military excellence and readiness. Department of the Army, implementation of executive orders related to transgender military service. And Department of the Army, fragmentary order here, amending what was already in place. Office of Undersecretary of Defense, Office of Undersecretary of Defense, clarifying guidance. This is additional guidance, this is clarifying guidance. Air Force here, prioritizing military excellence, and so on. So they just go through and explain that they have shown these departments the executive order and the guidelines that they want used during this situation. So with that, then what they did, then they just made a copy of this. It's like, I have this whole stack here, but it's just the same exact memo each time, over and over and over again. So let's take a look at it. All right, let's take a look at the memo that they're trying to use. We've got, again, keep in mind they're sending it to all of the different offices. They just are sending the exact same phrasing here. So February 26th, this is the guidance. We've got memorandum for senior Pentagon leadership, commander of the Combat Command's Defense Agency and DoD Field Activity Directors. And again, they just changed the name of who the memo was for, subject to additional guidance on prioritizing military excellence and readiness. So let's take a look and see here what they are putting in. And we'll just have to imagine how the judge feels about it. As directed by the Secretary of Defense in his February 7th memorandum prioritizing military excellence and readiness, it is a department policy that, pursuant to Executive Order 1418.3, prioritizing military excellence and readiness, the medical, surgical, and mental health constraints on individuals who have a current diagnosis or history of or exhibit symptoms consistent with gender dysmorphia are incompatible with the high mental and physical standards necessary for military service. I mean, could you be any more offensive? I mean, right. It's just so offensive. The attachment, hold on everybody, I gotta switch my pen here. Here we go. That's better. I feel better now. The attachment to this memorandum provides supplemental policy guidance and establishes a reporting mechanism to ensure department compliance. The policy guidance in the attachment 1 supersedes any conflicting policy guidance in the Department of Defense issuances and other policy guidance and memoranda, and 2 is effective immediately, will be incorporated into respective department issuances as appropriate. Yeah, it is offensive. So this is only 2 pages. I know it says 13 at the top, but it's really only 2 pages. So let's go through it. The following DoD issuances will be updated to reflect guidance in this attachment as appropriate. Department of Defense instruction here, medical standards for military service, and then they have amended that. DoD medical standards again for military service retention amended. Leave and liberty policy procedures amended. Military service academies. Oh my gosh, everybody, I can't even pronounce the word academies. My goodness, everyone, the tang. I need the tang. Just a minute. I'm dehydrated. More tang. Oh my goodness. Here we go. Senior Reserve Officers Training Course, so ROTC programs, Individual Medical Readiness Program. Again, these are the sections that have been changed here. The sections they're referring to, and then amendments have been made. Effective immediately, the following issuances, policies, and memorandum are canceled. Here, in-service transition for transgender service members, canceled. Defense Health Agency procedural instruction, guidance for gender-affirming healthcare of transgender and gender diverse active and reserve component service members. Acting Assistant Secretary of Defense for Health Affairs Memorandum, guidance for treatment of gender dysmorphia for active and reserve component service members. Principal Deputy Assistant Secretary of Defense for Health Affairs Memorandum, guidance for medical care in military treatment facilities for service members diagnosed with gender dysmorphia. The Assistant Secretary of Defense for Manpower and Reserve Affairs will be responsible for all data collection and reporting. The first report's due March 26th of 2025. All Department of Defense and military service policy rescissions and updates must be completed no later than June 25th. Service members being processed for separation in accordance with this policy will be afforded all statutorily required rights and benefits. So, I mean, come on. That's so crappy. It's just crappy. All right, so that was the letter, the memo that got sent out to all of the different departments. Again, it's, the same memo over and over and over again. So here we go. We've got service members and applicants for military service who have a current diagnosis or history of or exhibit symptoms consistent with gender dysmorphia. So let's take a peek and see what's going on. Policy. It's the DoD policy that A, service in the military services is open to all persons who can meet the high standards for military service and readiness without special accommodations. B, it's the policy of the United States government to establish high standards for service member readiness, lethality, cohesion, honesty, humility, uniformity, and integrity. This policy is inconsistent with the medical, surgical, and mental health constraints on individuals with gender dysmorphia or who have a current diagnosis or history of or exhibit symptoms consistent with gender dysmorphia. I mean, again, it's just so offensive. C, military service by service members and applicants for military service who have a current diagnosis or history of or exhibit symptoms consistent with gender dysmorphia is incompatible with military service. Service by these individuals is not in the best interests of the military services and is not clearly consistent with the interests of national security. Yikes! Individuals who have a current diagnosis or history of or exhibit symptoms consistent with gender dysphoria. I'm sorry, everybody. I'm sorry. I'm getting my words. I'm getting my words mixed up. Dysphoria. I apologize. I apologize. You know what I'm saying. You know what I'm saying, everybody, right? Dysphoria. Dysmorphia. I apologize, everybody. I was saying the other day, instead of Venezuelans. I just, my words got mixed up. I apologize. Here we go. Dysphoria are no longer eligible for military service except as set forth in sections 41C and 43C of this attachment. Service members who have a current diagnosis or history of or exhibit symptoms consistent with gender dysphoria will be processed for separation from military service in accordance with section 4.4 of this attachment. Characterization of service under these procedures will be honorable except where the service member's record otherwise warrants a lower characterization. Oh my gosh, this is just so awful. The department only recognizes two SEXs, male and female. An individual's SEX is immutable and changing during a person's life. Science, hello. All service members will only serve in accordance with their SEX, defined in Executive Order 14168, defending women from gender ideology extremism and restoring biological truth to the federal government as an individual's immutable biological classification as either male or female. Whereas standard requirement or policy depends on whether the individual is a male or female, e.g., medical fitness for duty, physical fitness, and body fat standards, birthing, bathroom and shower facilities, and uniform and grooming standards, all persons will be subject to the standard requirement or policy associated with their SEX. Well, yeah, Matthew, exactly. Pronoun usage when referring to service members must reflect a service member's SEX in keeping with good order and discipline salutations. Oh my gosh. Addressing a senior officer as sir or ma'am must also reflect an individual's SEX. I know, right? Why only women? Absent extraordinary operational necessity, the military services will not allow male service members to use or share sleeping, changing, or bathing facilities designated for females, nor allow female service members to use or share sleeping, changing, or bathing facilities designated for males. No funds from the Department of Defense will be used to pay for service members' unscheduled, scheduled, or planned medical procedures associated with facilitating SEX reassignment surgery, this kind of reconstruction surgery as treatment for gender dysphoria or newly initiated cross-SEX hormone therapy. Oh my gosh. Oh my goodness. What was it that they figured out? It was like 0.0017%. Consistent with existing law and the department policy, commanders shall protect the privacy of protected health information they receive under this policy in the same manner as they would with any other protected health information. Such health information shall be restricted to Personnel with a specific need to know, that is, access to information, must be necessary for the conduct of official duties. They don't understand what gender is. Kaya, I tell you what, this whole, oh my gosh, oh my gosh, it's like fingernails on a chalkboard to me. It drives me bonkers. Like I might mix up words because, I mix up words, but the concepts themselves, it's so difficult to get the mind cracked open enough to be like, dude, like this is this, man. This is this. And that is that. And, science drives me crazy. I was talking to someone on Amanda's live last night. What was his name? David, I think. And for some reason, he could not, well, I don't know. They could not figure out, he referred to himself as a he. So he kept saying and mixing words up, just mashing it all together. And it just was like, grr. They think bits are congruent with right. Oh my gosh, drives me crazy. Drives me crazy. And only because, in the beginning, I was the same way because I didn't understand. But I saw answers. You just have to go and look for answers. But if you don't, that's drives me crazy. Personnel shall also be accountable for safeguarding this health information consistent with existing laws and departmental policy. Applicability. The policy guidance applies to the Office of the Secretary of Defense, military departments, the Office of the Chairman of the Joint Chiefs of Staff, the Joint Staff, the Combatant Commands, the Officer of Inspector General of the Departments of Defense, the defense agencies, and the DoD field activities, and all other organizational entities within the DoD. Purple's purple, lilac's a shade of purple. Well, yeah, that's a good way. Education's a cure for. Oh, I agree. It's just, you can't just mash it all together, Whenever he's on, yeah, I don't know what was happening. There was a Canadian that came on. I was like, what? The Canadian? Let the Canadian talk. Oh my gosh. Responsibilities. 3.1. Under the Secretary of Defense for personnel and readiness here. They're rescinding issuances here, ensuring regulations, assistant here. So, okay, so those are the rules to implement the procedures. The J.K. Rowling, I tell you what, and let me just put this out there. I have not, and I'll be the first to admit it, I have not fully researched the situation with J.K. Rowling. I'm not sure if it's because I'm so disappointed that I'm unwilling to fully acknowledge and accept or what. But I do not have full knowledge of that situation, but I feel disappointment deeply. All right, 3.3, like nobody asked, but I'll just share that with everyone here, just for fun. All right, more rules here. Under the authority, directive, and control here, we're coordinating management and implementation. Hello. Dave, yeah, I don't even know. I mean, I'm not sure I've seen David on there before. Consider requests here. I'm sorry, everybody, I'm focusing, but I'm skimming through because we've got just procedural rules on updating new regulations, policies, and so on. So that's what this part of it is. We're not talking about changing anything here. So skipping. Okay, here we go. Let's get into procedures again. Hard for me because I'm really not. Oh, okay. So I refer to myself. Yeah. So my family calls me even medical. Yeah. Well, I mean, it's difficult. It's difficult, and I feel like anytime things change, people have a really hard time with it. I think one of the biggest issues with the pronouns, I'm just going to put it out there, all right, is a single person being a they. there is just like huge. There's, well, in Old English, they're not allowed to be a they if it's only singular, you know? So this whole idea that, you know, words mean different things as our society changes, that was huge. That was enormous, particularly with, you know, kind of the older crowd. So to just look at it and say this word means something different than it used to, I think is really hard for people to understand or accept. Again, my 2 cents. Here we go. Procedures. Appointment, enlistment, or induction into the military services. So applicants for military service and individuals in delayed training entry program who have a current diagnosis or history of exhibit symptoms consistent with gender dysphoria are disqualified from military service. Okay, that's so highly offensive. A history of cross sex hormone therapy or sex reassignment or uh, bits and bobs reconstruction surgery as treatment for gender dysphoria or in pursuit of a sex transition is disqualifying. Applicants disqualified pursuant to sections 41A and 41B of this attachment may be considered for a waiver on a case-by-case basis, provided there is a compelling government interest in accessing the applicant that directly supports war fighting capabilities. Wow, that's just awful. The applicant must be willing and able to adhere to all applicable standards, including the standards associated with the applicant's SEX. Oh my gosh. Wow. Look at that. Oh my gosh. So you might be able to get a waiver if you are willing and able to adhere to all of the applicable standards. So, wow. Applicants disqualified pursuant to section 41A and 41B of this attachment, not granted a waiver pursuant to 41C, shall not ship to initial entry training. Offers of admissions to military service academies or senior reserve officers training corps to individuals disqualified pursuant to these sections of the attachment shall be rescinded, except where the individual is granted a waiver. Senior reserve officers training corps students otherwise disqualified pursuant to these sections of this attachment may still participate in classes taught or coordinated by the Senior Reserve Officers Training Corps that are open to all students at the college or university concerned. All individuals enrolled or participating in the Senior Reserve Officers Training Corps, whether under contract or not contracted, will follow standards for uniform wear consistent with the individual's SEX in accordance with Section 5 of this attachment. Oh my gosh, this is really, wow. So offensive. Individuals disqualified pursuant to these sections of this attachment are subject to separation from a military service academy in accordance with DOD or from the Senior Reserve Officers Training Corps in accordance with this section unless the individual is granted a waiver consistent with the section 4.1C of this attachment. Absent any other basis for separation or disenrollment, such individuals will not be subject to monetary repayment of educational benefits or recoupment, nor subject to completion of military service obligation. Wow. Yikes. Oh, all right. Medical care. So let's just peek in here. You've got a responsibility to maintain health and fitness, medical readiness requirements, including mental health, unscheduled, scheduled, planned surgical procedures, anything involving the SEX reassignments are all canceled. Wow, with gender dysphoria. Wow. I mean, so if you're in the process, it's just canceled. What? I mean, wow. Oh my gosh, the damage. Oh my gosh. Across SEX hormone therapy for service members who have current diagnosis or history or exhibit symptoms that begin prior to the date of this memorandum may, if recommended um, by a healthcare provider in order to prevent further complications, be continued until separation is complete. All right, well, at least there's that. That's not good. That's not good. Service members can consult concerning a diagnosis of gender dysphoria and receive mental health counseling for a diagnosis of gender dysphoria. The retention or processing for separation of such service members will follow the procedures in Section 4.3 and Section 4.4 of this attachment as appropriate. Retention. Service members who have a current diagnosis or history or exhibit symptoms consistent with gender dysphoria are disqualified from military service. If they have a history of cross-SEX hormone therapy or history of SEX reassignment, they are disqualified from military service. Disqualified to sections 4.3a and 4.3b of this attachment may be considered for a waiver. Again, this is that same language. If the following criteria is met: service member demonstrates 36 consecutive months of stability. Wait a minute, I'm seeing spots. I'm actually seeing spots. Let's back this bus up. Let's look at this. I'm sorry, what? Service members disqualified pursuant to Section 4.3a and 4.3b of this attachment may be considered for a waiver on a case-by-case basis, provided there is a compelling government interest in retaining the service member that directly supports warfighting capabilities and the service member concerned meets the following criteria. Number 1, the service member demonstrates 36 consecutive months of stability in the service member's SEX without clinically significant distress or impairment in social, occupational, or other important areas of functioning. And I know, right? The service member demonstrates that he or she has never attempted to transition to any other SEX than their SEX. And 3, the service member is willing and able to adhere to all applicable standards, including the standards associated with the service member's SEX. Oh my gosh. Oh my gosh. The trauma. This is so, all right. I mean, right? This is really bad. 36 consecutive months. Wow. Wow. Oh my God. Yeah, conversion therapy, June Marie. Yes. Oh my gosh. Well put. I'm going to have to take a tang break for a moment because I'm seeing the spots. Seriously, the damage that something like this would do. Well, exactly. Oh my gosh, the damage. All right, 4.4 separation. Service members who have a current diagnosis or history of or exhibit symptoms consistent with gender dysphoria and are not granted a waiver pursuant here will be processed for administrative separation in accordance with and afforded all applicable administrative processing protections. The secretaries of the military departments will direct administrative separation to 1, any enlisted service member prior to the expiration of the member's term of service following a determination that doing so is in the best interest of the relevant military service, or 2, any officer whose retention is not clearly consistent with the interests of national security. Oh my gosh. Service members are ineligible for referral to the disability evaluation system when they have a current diagnosis or history of or exhibit symptoms consistent with gender dysphoria, not constituting a physical disability. That's actually a really good question. Because I mean, I'm not a doctor of medicine, and I mean, is it? I mean, gender dysphoria isn't technically a disability, is it? Is it categorized as a disability? I'm not sure. That's really okay. I was gonna say, I'm like, I don't think that's a disability. I think that's different. Thank you very much, everybody. I appreciate that. To treat humans like this, exactly. I mean, this language is just what the judge was talking about. The language itself is offensive. It's just offensive. Dysphoria drives the distress. To see if it's a diagnosis. Yeah, I'm wondering. I mean, because if it's, I would say, even though not classified technically as a disability, it's a medical condition. It's a medical situation that should be covered under the ADA. That means you shouldn't be able to discriminate against somebody because of it. So I mean, we've got a civil rights situation, obviously, but then now I'm wondering if you're discriminating based off of a medical condition, if we have another level of, yeah, the ADA says yes. Okay, well, I mean, you can have a ADA qualifying condition that isn't technically a disability. So, I mean, that's an interesting a place where we're crossing roads, I think. Oh my gosh, Jennifer, yes. But that raises an interesting question that they're being discriminated against. You're not allowed to be discriminated against because of a medical condition. It was moved in categories. Okay. Okay. Interesting. From the Fourth Circuit. Oh, that's interesting. All right. Well, again, offensive language, yes. Does HIPAA not apply? Great question, Ruth. Excellent question. I'm not sure how HIPAA and the military interact. I think that's an interaction. So, is a condition that causes distress and discomfort when the gender you identify with conflicts with the sex that you are assigned with. Right, right. So, and I think somebody had just said it earlier. The dysmorphia causes the distress, and that's what creates the situation. Okay. Right, right. Autism is also just right. I mean, but I mean a spectrum, right? I mean, spectrum. So, oh my goodness. Yeah, I would say that would be a second level to go under because they're trying so hard. The reason also I bring it up is they're trying so hard to not use that term just transgendered, right? They're trying to dance around, and this is what the judge said too. They're dancing around the issue by saying gender dysphoria, but when you're talking about that, now we're talking about a medical situation. Yeah, what is normal? Oh my gosh, so true, right? So true. So it would have with if they just used the word transgender, again, everyone, I'm just trying to think of the constitutional questions here. If you just use the word transgender, now we are in a constitutional civil rights equal protection situation. But if you're using gender dysmorphia, now we've got not just a civil rights issue, but we've also got now a medical discrimination case, right? Mental screenings before they let people in. That's a good question. Yeah, how would they know? Not all trans people have. Well, that's the other thing too, right? Because it's the dysmorphia is. I mean, that's like we're dealing with a negative situation where some kind of there's a mix up that's causing anxiety, but not all people that are transgendered are going to have that kind of a negative mix up uh, response. There you go. That's how that goes when I'm trying to explain medical stuff. Okay. A concept designated in the DSM 5 as clinically significant distress or impairment related to gender incongruence, which may include, right, okay. Yeah, that's what I'm saying. That's what I'm saying. Oh my gosh. I mean, can we add another level of problems for people can we just add more? Like they like this this class of people that we're dealing with here, this protected class of people, I mean, it's just like piling more and more on top of it. It's very distressing. All right, back in it, everybody. I know I keep getting sidetracked by my own soapbox here. Here we go. So, this is offensive. Service members may be referred to the DES if they have a comorbidity or other qualifying condition that is appropriate for disability evaluation processing in accordance with the DODI prior to processing for administrative separation. The more we're accepting, oh my, right, Cynthia, right. Well, and Bellicose, welcome, good to see you. On the Venezuelan, not the Venezuelan, El Salvador case. Oh, she'd be amazing. But my understanding, hold up though, and correct me if I'm wrong. My understanding is that she stepped down and the current judge on that case like took her spot. Is that right? Was she the chief judge? I'm not sure. I mean, she didn't step down for any, negative reason. It was just like, let's move on or, rotate responsibilities. For some reason, I have it in my head that she was the one on the bench before he was the chief. I don't know. Why don't they enforce about 1 to 3 in the military? Well, and a problem here, of course, with the SAing in the military is we've got a huge SAing issue in the whole country, and it is amplified within the military. She's on the federal court, not the DC circuit. Okay. Know how their different jurisdictions are. Okay. Good point. I must be thinking of someone else then. Well, I don't know. I'm getting a lot of stuff all mixed up in my brain right now. There's just too many cases. There's too many cases, everybody. And let me dive back in. Service members who are processed for separation pursuant to this policy will be designated as non-deployable until their separation's complete. Amplifying the White House. True. Oh my gosh, this world we're living in right now, everybody. Yikes. Service members who have a current diagnosis or history of or exhibit symptoms consistent with gender dysphoria may elect to separate voluntarily within the 30 days following signature of this guidance. Such service members may be eligible for voluntary separation pay in accordance with the code. Service members eligible for voluntary separation pay will be paid at a rate that's twice the amount of the service member would have gotten to be eligible for involuntary separation pay. So this is when they're trying to pay them to voluntarily step down here. Service members separated involuntarily pursuant to this policy may be provided with full involuntary separation pay. All right. All enlisted service members who are involuntarily separated pursuant to this policy will, if desired by the service member, be afforded an administrative separation board. All right. All officers who are involuntarily separated pursuant to this policy will be afforded a board of inquiry if desired by the officer. Service members identified here with over 18 but less than 20 years of total active duty service. Can you imagine? Let's take a minute again. This makes it angry. Can you imagine over 18 years of military service and you get up in the morning and they're like, you're done because of this? I mean, it's just mind-blowing. So we've got over 18 but less than 20. They are eligible for early retirement under the Temporary Early Retirement Authority. Eligible service members here, National Guard members when active duty for 30 or more consecutive days who are processed for separation and covered dependents remain eligible for TRICARE, so that's health insurance for 180 days. Service members choosing a voluntary separation will not have to repay any bonuses received prior to the date of this memorandum, even if they have a remaining service obligation. The military departments may recoup any bonuses received prior to that date of this memo for service members choosing to be involuntarily separated. So they could take your bonuses if you don't voluntarily leave? Like, what? That's, oh my gosh. Oh my goodness. The secretaries of the military department shall waive any remaining military service obligation for service members who are separated pursuant to this policy. Separation proceedings for individuals here will be initiated after the secretaries of military departments complete the requirements. Nothing in this attachment precludes appropriate administrative or disciplinary action for service members who refuse orders from lawful authority to comply with applicable standards or otherwise do not meet standards for performance and conduct. Hold up, wait. Does this mean they could be, if they don't, dress or go into the box created here for their born sex situation, they could be disciplined? Is that what this is saying? Is that here? So you could have a disciplinary action who are refusing orders to comply with applicable standards? Right? So what? Oh my gosh. That's just, okay. That's awful. Oh my goodness, everybody. Court martial. Oh my gosh. Oh, that's so awful. Oh, these people. Oh, awful. All right, SEX. Well, great. Military records. All military records will reflect the service member's SEX. Okay. Standards here. So let's take a look. Can it get, oh my gosh, that's the question. Can it get any worse? It seems, that's what I'm thinking, Star. That's what I'm thinking psychologically. Access to intimate spaces will be determined by service members' or applicants for military services SEX. The military services will apply all standards and involve consideration of the service members' SEX to include but not limited to uniforms and grooming, body composition assessment, medical fitness for duty, physical fitness and body fat standards, birthing, bathroom, and shower facilities, military personnel, DRUG. I don't have to spell stuff out anymore. I'm over here on the tube. Military personnel drug abuse testing program participation. All such shared intimate spaces will be clearly designated for either male, female, or family use. Yeah, I'm battling the Hulk right now. I'm battling the Hulk. I'm just like, Madison, rein me in, man. Oh my gosh. Exceptions to this requirement may only in cases of extraordinary operational necessity during deployments or in austere environments where space is limited. Commanders will prioritize unit cohesion and readiness while adhering to this policy. How is this judge even reacting to that? She, after that 80-page decision that we just went through, how is the judge's response going to be? Again, this was just filed on the 21st, so 2 days ago. I cannot even imagine how this is going to just be like, what? Like, just, she's going to be upset. Administrative absence for service members with a current history of what? Or diagnosis of or symptoms consistent with gender dysphoria. Administrative absence, oh my gosh, in order to maintain good order and discipline in accordance with Section 5 of this attachment, the Secretary of the Military Department concerned may place service members being processed for separation under the criteria in Section 4.4a of this attachment in an administrative absence status with full pay and benefits until their separation is complete. Service members in an administrative absence status in accordance with this section will be designated as non-deployable until their separation is complete. Service members in an administrative absence status in accordance with this section will complete the transition assistance program in accordance with this section of the law. I just can't even imagine putting 18 years in the military, waking up. I mean, one, from one day it's fine, and you're a decorated military officer or military person at whatever level you're at, and the next minute you're out. I mean, that's just like in 24 hours. Oh, sure. Yeah, I'll come back and do a quick summary. We are on the very last page of this abomination here. Yes, you got it. You got it. Absolutely, absolutely. Thank you so much, John, for that. Let me finish up here, the last little paragraph, and then we'll go back and I will do a quick overview of her order. Reporting. So here's our reporting requirements. No later than March 26th, and every 30 days, submit via correspondence, task management, whatever, a memorandum providing the following. 1, identification of all DOD, Military Department, military service issuances, regulations, policy memorandum. 2, status of updates to the aforementioned people, draft revisions to the aforementioned people, status of system records update, status of in progress of the separations, status of progress on compliance, section 5. All right. So, oh my gosh, I know. Oh my goodness gracious. All right, so that's awful. That's just straight up awful. Again, to remind you where this came from here, we are talking about the judge had requested this information be filed because she said to the defendants, what have you told your people? What is it you're sending out to your people? I want to know what it is. And then they filed this. So let's go through. I think one of the best ways to summarize her order, she has a 2-page summary order. Let's go through that. I'll just finish on that because I don't think I could do it any better than she does it herself. All right. So here we go. Again, just to remind everybody, I've gone through. Sorry if I get too close to my mic, everybody. My phone's really close to my face. This is her order here. It's document 89. This is the case number. And she did grant an injunction based off of going through an analysis required. 4 different components needed for an injunction. She did basically found no evidence to support anything that was said in the proclamation or justification for any of this. So that's really where she's at. Here we go. For the reasons set forth in the accompanying memorandum order, the court hereby grants plaintiffs renewed application for a preliminary injunction, orders defendant Hegseth in his official capacity as Secretary of Defense, Army here, Navy here, Navy, Air Force, Defense Health Agency here, are preliminary enjoined pending further order from this court from implementing Executive Order 14.18.3, as well as additional guidance on prioritizing military excellence and readiness. Hold on, wait a minute, hold on here. So this was the Hegseth. Okay, so this was the Hegseth order. So this is the executive order and then the Hegseth policy here. Or additional guidance on prioritizing military excellence and readiness. The effect of the court's orders to maintain the status quo of military policy regarding transgender service that existed immediately before Trump issued the executive order 14.18.3 with article, really, for speaking against, oh my gosh. The policies described in the Department of Defense's Instruction, Volume 1, here, medical standards and such, court orders that pending further order of the court, defendants shall maintain and continue plaintiff's military statuses. It further orders defendant to take all steps necessary to effectuate this order. It further orders defendants to provide written notice of this order by 5 p.m. Eastern on March 21st to all branches of the Department of Defense and to any other entity responsible for implementing military policy. It further orders defendant to file with the court confirmation by 6 p.m. on the 21st that it's provided the written notice of the order as the court has directed. Further orders parties to file a joint status report by March 31st. So this is our next court requirement, where, and a lot of our judges are doing this, and this is pretty typical. When you have an order like this, is they will say, you need to tell me what's going on, what's the status of making sure my order's being followed, which is, you know, kind of the baloney that's going on with the El Salvador situation. Then informs the court defendants of compliance. Here, the court stays the effect of this order until 10 a.m. Eastern in order to get that stay if they wanted to file it. So that's the bare bones here with her order. But to just kind of summarize how I saw her decision here is I thought she did a really great job of really saying, you know, this isn't about some military readiness. And in fact, I think probably my favorite part of this, and I'll go ahead and reread it because I think this is absolutely the best part of her opinion here. All right. The president has the power, indeed the obligation, to ensure military readiness. At times, however, leaders have used concern for military readiness to deny marginalized persons the privilege of serving. Quote, fill in the blank is not fully capable and will hinder combat effectiveness. Fill in the blank will disrupt unit cohesion and so diminish military effectiveness. Allowing fill in the blank to serve will undermine training, make it impossible to recruit successfully, and disrupt military order. First minorities, then women in combat, then gays filled in the blank. Today, however, our military is stronger and our nation is safer for the millions of such blanks and all other persons who serve. So this has to be like one of my absolute favorite pieces of her whole order, is which is amazing. So that's what she's saying. She's saying that, you know, the defendants are saying this is necessary and they have absolutely no evidence or proof or anything to support that it's necessary other than animus. And the language that they're using is derogatory. And that's what she says too. She's like, literally, your language is derogatory. You are clearly targeting a group of people. And although you're not using the word transgender in your proclamation or your executive order, that's exactly what you're talking about. And you've admitted to it. Another thing too that I thought was very powerful in her writing, in the opinion, was when she said the defendants agree. So she's going through and she's setting it out. And then she said in bold print, which you know that's a big deal, she said, and defendants agree. Defendants agree. So they're not even opposing. They understand what they've done. Let me just get to that moment because I think that's really an incredibly important. There it is right here, page 4. Here, transgender persons have served openly since 2021, but defendants have not analyzed their service. That's unfortunate. Plaintiff service records alone are Exhibit A for the proposition that transgender persons can have the warrior ethos, physical and mental health, selflessness, honor, integrity, and discipline to ensure military excellence. Defendants agree. They agree that plaintiffs are mentally and physically fit to serve, have served honorably, and have satisfied the rigorous standards demanded of them. And then she goes on to say, plaintiffs they acknowledge, have made America safer. So why discharge them and other decorated soldiers? Crickets from defendants on this key question. So I think, is this precedent from New Jersey to Louisiana? Is there precedent when they pulled Khalil? Well, right, Navy vet. So, not a dependable precedent. No, that's why the court ordered them back. Mm-hmm. Yeah, that was a jurisdictional question, and they're like, dude, you need to move him back. He needs to go back because uh, you're screwing up. There's a decision that came out on Khalil, and the court does explain that quite a bit. So he does a good job. So that, I'm sorry, the Khalil case is huge. For anyone who's wondering, we have this case, Khalil v. Joyce. That's our Columbia University student who was detained and in New Jersey and taken to Louisiana. So that happened. Someone said it was. Okay, okay. I got you. I can't catch everything in the chat here. But anyway, so that's my summary. I'm all over the place, everybody. I'm all over the road here. I'm all over the road. But that is the summary then for her decision here, which again I think is incredibly well written. I think this is going to be great for other circuits to come in and see. This is why I thought she was in DC. I she's not in the DC circuit then? I don't know. I don't know where I got that from. I'll have to double check and see what we're talking about here, but she's done a great job here, and just again presenting the facts. Like we're not playing around here. I'm just telling you, you don't have any facts or evidence to support what you're saying, and if you don't, then you don't get to have what you want if you can't support it legally. So it turns all different colors sometimes. The Hulk's been coming out a lot, everybody. The Hulk's been out a lot recently, all right? So I had to. I've just absolutely had to calm down multiple times because I just can't even help it these days. Yes, there's been a lot of hulking, and I'm trying to not do it in front of other people. But of course, then what I try to do then is meditate with Judge McAfee. We just do some meditation. We're like, it's okay. Everything's cool. We're chill. It's no big deal. NBD, no big deal. It's all right. Oh, poor Judge McAfee. Man, I can't even imagine how he's doing. She is in DC. Okay, okay, thanks. Okay, thank you, John. Yeah, I'll have to take a look at that because for some reason, I thought she was, but I've got all the jurisdictions messed up. Right now, we've got cases on appeal in the First Circuit, the Fourth, the Ninth. Um, I think those are the big ones. I mean, and there's multiple uh, interlocutory appeals that are going, as well as appealing the injunctions themselves. So there's quite a bit actually going on. I've had to get a whole new flag system. I had to get a whole bunch of new flags, everybody, to put on my Post-its because of all of the appeals. So, what happened to the RICO? Well, the last we've heard, the Georgia Court of Appeals said that DA Willis was disqualified from doing the case, that it needed to be turned over to another office. She has appealed that. Now, the result of that appeal, I do not know at this point. I do keep, an eye on it, but it's not having much movement. Yeah, I mean, all those people are still charged. They're all still indicted. Here you go, in case you were wondering. They're all still indicted. We still have 4 guilties. Some people might say, like, oh, they got rid of it too soon. But quite frankly, I thought it was smart. I thought they did a smart job. I would have recommended this to my clients. Get rid of that RICO, plead out to a couple of years of probation, and then you're done. Like, they're going to be done even serving their probation out, before these people are finished. Meanwhile, these guys are getting dragged through it, paying attorneys still. So, not a bad idea. Yeah, I need to give a heads up before I show that picture. Sorry. Oh my gosh. All right. All right. So that's what I've got, everybody. That's what I've got on the Talbott case. Again, we've got 133 cases running. Only 1 case requesting sanctions. That still hasn't happened yet. I would say probably if you want to know the biggest the absolute biggest issue going on with all of these cases against the administration is, and we, El Salvador is its own animal, but probably the biggest issue are the frozen funds. The funds that Congress has designated to go to certain places that they are refusing to send out. That is absolutely the biggest area right now. We're seeing over and over and over again where these judges are getting so mad at this point that they're like, we're just about it. This is about it. I've had it. So that's going to be the next big area. Will every case wind up in SCOTUS? Possible. It's possible. I don't know, though. I don't know. I mean, they're going to keep appealing it. It's all about time because with the Department of Justice, uh, basically under his command, he can just like keep going and going and going and having everything filed and filed and filed because he has the Department of Justice under him. What I'm seeing though are a heck of a lot of attorneys unwilling to do this kind of stuff. So that's the other thing is these attorneys are like, I'm out. I gotta go. And I love to see that. I hate to see the loss of work. If you're not in the Department of Justice just for fun, I mean, if you're just in it to make money, you're in a big law firm doing work to make yourself some cash, all right? But if you're in the Department of Justice, you're doing it for justice. You're doing it for the love of the game. And so it's really sad to see a lot of these attorneys that have just, I mean, this is their whole life is in the pursuit of justice and stepping aside and saying, I just can't be a part of this. So hopefully they'll come back. Yes. Well, thank you, Kale, and happy birthday. Happy birthday. When the executive branch oversteps, I would imagine the lawsuits will go to SCOTUS eventually. Quite right. I think so. It's just a matter of how quickly they'll go. Some of them are moving faster than others. So I think one of the next ones we'll see will probably be the forced back to the boards cases. Those are all being appealed. The probationary employees are all being appealed, so those are going to go. Willing to take the gamble, right? I mean, right. And again, it really kind of goes against the grain. It's un-American for the bad guys to win, and so that's why it just seems like it's so awful. But on the other hand, there's nuances. Not all bad people are just 100% bad. There's just a lot of nuances that haven't been part of our culture here. And so it's kind of a difficult moment. Anyway, with that, everybody, I will say thank you so much for coming and joining me tonight. I appreciate it. Thomas, good to see you. Kaya, of course, happiest of birthdays. Oh my gosh, VC, all the moderators in here. John, great to see you. Star, of course. I think the judges are paying attention to his cabinet, saying the media interviews. Absolutely, they are. I have no doubt that all of these judges are keeping their eyes on everything that these people are saying, because that's all evidence, and we love that. We love that for us. You are so welcome in Bellicose. We'll have to chat again about this for sure. This case is a very, very interesting case. We'll see how things keep going forward on it. But thank you again, Navy Vet. Always good to see you. Have a good night, everybody. Again, just a friendly reminder, I am here on YouTube on Tuesday, Thursday, and Sunday nights. So watch for me. My next one will be Tuesday. So take care, everybody. Have a good one. Thanks for coming by. I appreciate it.